So ending with a lawyer on a Friday afternoon,
Great idea.
it's obvious it wasn't plan A, right? Thanks, James. It's going to be hard to approach this last speech with that energy. So, for those of you who don't know me, I'm a lawyer who's practiced pretty much exclusively in workplace relations and employment law over the past 25 years. The first thing I'd really like to say is welcome to the HR Nicholls Society, back to the debate. It's been a wonderful agenda and a lot of interesting ideas have been exchanged on a lot of topics. But my topic, aligned with my expertise, is designed to bring us back to, I guess, the IR reform element of the debate. I'm not an intellectual, I'm not an academic, and I can't approach these things with the level of conceptual understanding, that policy-based understanding that some of the other speakers have. But what I can bring is a practitioner's point of view, the realities of leverage on the ground. And what I'm going to try to do is to apply those perspectives to tell you how this might play out over the next 3 to 5 years. So what are we going to cover as we step through the loophole? I'm going to start very briefly with some key labour relations metrics over the last 15 years or so. A lot of people have touched on these. I'm not going to spend a lot of time on it. Having done that, we're going to look at the stated objectives of this system. What is it saying it's going to achieve? And having done that, we're going to look at some of the reform elements and how they will interact on the ground. And that is why, in my submission, they are particularly significant. It is not just the individual impact of any of these reforms, it's their combined impact in what is a wholesale re-regulation across the entire labour market. And then I'm going to give you some predictions. Like a lot of people on this stage, the predictions are not all great for the interests of employers and, I would say, for the community. I hope I'm wrong, but I'm making the case today that in 3 to 5 years, the case for reform will be overwhelming. And to pick up on something that Judith Sloan said last night, she examined the moral impetus for reform through Ray Evans's lens and the economic lens for reform through her lens. I will say to you today that both those lenses will provide a compelling case for reform, and indeed a compelling case for pro-worker reform. So, on to some of the detail. You don't need to be able to read this slide. It's about the trends. We've heard a lot about some of the information on this slide. The key call-outs are the image on the right says we want a lot of these things tracking upwards, most of all labour productivity, and the reality is they've been tracking downwards for a long period of time. We can call out the union membership numbers. They will be intimately familiar to everyone in the room. Just about everybody's mentioned them. We have a private sector number that's hovering around 8% and an overall union membership number of 13%. Now, one of the things that I'm going to call out today is democracy, workplace democracy. Who gets to make decisions in workplaces under these systems? And those key numbers, the 8% and the 13%, are at the heart of the critique of who gets to make decisions under this system. So, stated objectives of the reforms. For anyone who's read them, they'll see what they are. I will say one other quick thing here. Conscious that I'm standing between you and the bar, you have exactly 19 minutes to listen to me from now. And if I go longer than that, well, that's at my expense. Okay. Stated objectives of the reforms. devoted attention to a permanent employment model. Now, that is an ideological position. It says that the best form of employment is permanent employment. It means that other forms of engagement, both as employee and as other forms of worker engagement, are suboptimal. So we're seeking to drive a permanent employment model. Now, the moment you focus on one way of doing things, you're doing it at the expense of the others. And the logical consequence is a narrowing of options for employers and employees at workplace level to be able to tailor their arrangements. And I'll come back to that. We're looking to increase wages and entitlements. Now, that is a noble objective. I think everybody wants to be paid more. Everyone deserves to be paid more for the most part. But being paid more for what? What sits behind the increase to wages and entitlements? Is it better workplaces or not? And I'll come back to that. Putting collective agreements at the centre of the system, effectively at the behest of what is often that very small group of people who make up the union membership in most workplaces, but that can impose those terms and conditions on the workplace as a whole. And increasing union rights. So this Act does that in a range of ways, and my thesis to you, it does it in a range of undemocratic ways, effectively placing unions as institutions in the system, not mandated or legitimised by the support of a workplace or the support of a group of workers, but rather acting often in their own interests and based on their own predominant agenda. These are the reform elements we're talking about. I'm not going to go through this. If anyone wants to look at them later, they'll be available. Broadly, we're talking today about the same job, same pay reforms and the closing loophole reforms that have taken place in about 4 tranches between 2022 and the beginning of this year. The key takeaways in the brown box that this is labour market-wide regulation of worker rights in a way that we've actually never had in Australia before. And under a system that is not looking at the circumstances of workplace participants at the workplace level, but rather looking at industry or, in some cases, national a national framework for setting terms and conditions independently of the workplace participants at the enterprise level. And this is the first time we've stepped away from that since, say, 1993. So how do these reforms interact? People will be familiar with the workplace delegate reform. Now, anyone who's familiar with industrial relations internationally will understand that there is usually a threshold test for a workplace to unionise, for employees to choose to become represented by a union. Often that's by majority. So, for example, in the United States, there is a process by way of petition, where if a group of people wish to be represented by a union, that needs to be at the front end, determined democratically in that workplace, and a majority of those employees need to want that. In Australia, we've chosen to set the role for workplace participation by unions at 1. It only takes 1. And the moment that a union has somebody who wants to be their union representative in that workplace, to advocate for the union, to organise, to exercise the various privileges that this institutionalised unionism under our system has, they can do that from a threshold of 1. Now, I would ask, where's the democracy in that? Having got your threshold of 1, there are a series of individual rights that have been introduced and expanded over the course of the last 15 years and substantially expanded over the course of the last 2 years. These individual rights enable unions to select an issue, let's just say, for example, flexible work, and to access the Fair Work Commission to drive that right to arbitration. Now, in itself, perhaps nothing wrong with that, although I will come back to that point as well. but it enables effectively a testing of reasonableness around pretty much day-to-day decisions. Should your flexible workday be on a Tuesday? Should it be on a Friday? Instead of having to work that out at the workplace level between employer and employee, now that can be taken to the Fair Work Commission and it can be arbitrated in a litigation-based process that requires evidence and submissions, often legal representation, day-to-day workplace decisions that have become a source of litigation and controversy. From that, there's a range of other rights that can be exercised. Rights to be consulted about workplace change, the capacity to exercise dispute about workplace change. What's important in that? It becomes a very important protection of the status quo for workplaces that don't want to go through change processes. Unions can use these processes to win both time and delay and potentially a basis to negotiate compromise. Now, nobody's saying that people shouldn't talk about workplace change. No one's saying they shouldn't be able to exchange ideas about it. But now we have a system that ends in arbitration by third parties in relation to a much broader range of those disputes, so that where our agreement is not reached, it's externally imposed. We need to be careful about that, in my view. We then get into the collective bargaining triggers, which a number of different people have talked about. I want to call out two things in collective bargaining. There is one change implemented late in this process that fundamentally alters the balance. And it is a hamstringing of the discretion of the Fair Work Commission. The legislation provides that through a collective bargaining process, the Fair Work Commission, after 9 months, can decide that a dispute is intractable. It then is able to arbitrate any outstanding issues. But the measure that is most objectionable is that in exercising those powers, it is not permitted to make any or to order any outcome or to impose any term and condition that is less favourable than what exists to employees now. So if you think about large workplaces that have had traditional industrial relations arrangements, where there are instruments that have terms and conditions that are no longer fit for purpose, those always have led to difficult disputes in our labour market. Trying to remove established terms and conditions because they are no longer relevant to the way that a company operates, but that employees want to preserve, it's rich ground for a dispute. But when, under the old system where there was a threshold where those things could be arbitrated, it was quite hard to reach. It required significant harm, effectively. Now, that threshold is reached simply by waiting out the 9-month period. And then arbitration in the old world was accessed. People had their existing conditions at risk. If you ended up in an arbitration scenario, both sides could lose. You had to make your argument to the Commission, and the Commission, in its King Solomon-esque type way, would find a solution that commonly would grant the change that the employer sought. Now, the reason for that is equity, good conscience, and the merits of the case. The central tenet about how the Commission decides things. You could, as an employer, persuade the Commission that there was a business case to implement the changes that were required. Now, the law says the Commission cannot remove that entitlement. It cannot make an order that is less favourable than what exists before. So a union in that traditional labour relations negotiation comes to the table with no risk of downside, with only the possibility of more. Arguing for a pay increase in circumstances where they can stand in the way of change, even where there is an overwhelming merit case. Now, in my view, that is fundamentally broken. That is not what the Fair Work Commission is supposed to do as the umpire. It comes as the umpire with one hand tied behind its back and even if it thinks change is warranted or that change should be exchanged for the pay increase that is sought, which would be the typical outcome, it can no longer do that. A union comes in unable to lose, and that means that it approaches the entire bargain differently. It means achieving change becomes much more difficult. There's no impetus for the union to make concessions during the negotiations. Bargaining processes become protracted, more difficult, more costly, and ultimately ending in this deeply skewed arbitration. So that's problem one. Problem two, which a lot of people have talked about, is the multi-employer bargaining and the same job, same pay order agenda, which will be sitting behind all of the things that are happening at workplace levels, all the bargaining that plays out directly between employers and unions. Sitting behind that will be the industry movements, where there are orders made that apply to multiple employers, and then the capacity, without the consent of that workforce necessarily, without the consent of that employer, certainly, those separately negotiated terms and conditions can be applied to any workplace that is doing work that's within the scope of that instrument, as long as it is substantially the same work. Now, again, if you want to see the cynicism of the system around this, you only need to listen to what Tony Burke said about these reforms when he was introducing them. He said, very few people will end up covered by multiple employer agreements because all of them will make their own enterprise agreements beforehand. But of course, that's not aligned with what unions want to achieve. They want to achieve industry-based regulation. They want to achieve multiple employer thresholds that they can then apply more broadly across an industry that they otherwise have been unable to organise within because they only represent 8%. So this is an important statutory driver that extends a union's influence well beyond its democratic representation. And fundamentally, that will be problematical in my view. Okay, so that's how the reforms interact. I've thrown in a slide just for fun. This is just for impact. As a lawyer who represents clients all the time, we've got a really good new easy test for casuals that all businesses can understand. 15-part test with, of course, the capacity for it to be revisited by courts or tribunals at any point in time during the life of the employment relationship. And yeah, you should try running the average small business owner through that. But the bottom line is that they have no prospect of understanding that. How can we have, for a mode of employment that every employer encounters, which is why I've chosen this one, everyone turns their mind to casual employment. It's often a very sensible way for people to enter the workplace. Many of us as students worked as casual employees. But instead, what we see here is a level of complexity that no non-expert could understand or predict, because it's a travelling test around this thing called a future advance commitment. I mean, I don't know what a future advance commitment is. I've been doing this for 25 years. It's in the eye of the beholder. So what hope does an employer have, particularly an employer without any real expertise or support, have to do to make these decisions? Yeah. Now, the challenge with this sort of legislation that's really designed to make casual employment undesirable, let's be honest about it, the real challenge with it is it has unintended consequences, because employers will modify their arrangements to avoid the risk. They will stop having settled arrangements for casual employees throughout their university degree, because if they work the same Thursday, this test creates risk for them. So now we need to have casual employment being used differently in the labour market in a way that's actually counterproductive to both workplace participants in a lot of examples. It ignores the legitimate role that casual employment can have. And it's incomprehensible. Okay. 4 minutes, 5 predictions. You ready to go? Yeah. Buckle in. Prediction 1. These increased individual rights will be irrelevant to almost all employees. This is about 5% of the system. It's about the 5% of employers and employees who are unreasonable. Anybody who's employed anyone or any group of people for a length of time, you're going to trip upon an unreasonable employee. You're not going to be able to agree about whether it's Wednesday or Friday. Someone's got to intervene to impose the outcomes. That's not the case for most employees. Most employees just work it out. Most employers just work it out. But for the 5%, we've now set up a complex litigation-based system ending in arbitration to deal with these concerns. And whilst it will be irrelevant to most employees, employers can't say that. It's going to affect most employers because at some point in time, everyone employs the unreasonable person who won't accept what you regard as a reasonable judgment and now has access to arbitration to deal with day-to-day issues. Is that really where we want the focus of the time and attention of organisations like the Fair Work Commission being? Do we really want employers having to defend day-to-day decisions by way of litigation with the time and cost that brings? But that's what will happen. Prediction 2. Unions with their new institutional role may well flourish under this system. Not all of them will, but many will. But I say that very few of them will actually manage to grow their membership as a result of this institutional role. And that is because of the lack of workplace democracy that is actually central to the legitimate role that unions play. They should be representing the interests of employees and doing what employees want, not imposing their own agendas. Picking up on another thing that Judith Sloan said about that, unions have got their own money now. They're not as financially dependent upon members anymore. Their business model that was very heavily tied to membership is now less tied to membership, a product of the declining membership, but also a product of the legitimacy of their representation declining. What this legislation does has granted unions effectively their absolute wish list, which is an entrenched role in the system to pull the levers even where they don't have membership or worker support to drive those outcomes. That is going to be very problematical. Prediction 3 is that the statutory compromise of the Fair Work Commission will be exposed as bad policy. Now, you only need to talk to members of the Fair Work Commission to know their frustration. Many of these claims they now need to deal with on the individual rights space frustrates them deeply. They can see from the beginning that they're not meritorious claims, and the vast majority of them fail. But now, as their more important role as the arbiter of collective terms and conditions starts to kick in, both for individual workplaces through enterprise bargaining and through groups of employers or indeed industries through multi-employer bargaining and same work, same job, same pay orders. The hampering of the Commission to actually fully exercise its judgment, to apply equity, good conscience and the fairness of the case will become apparent. It will become clear that the legislation is designed to compel the Commission to have regard to certain things and not have regard to others, to use it as effectively as a tool to produce outcomes rather than as a genuine umpire. And that will be problematical. Prediction 4, the reforms are not going to produce better workplaces for anyone. When you actually think about what makes good workplaces, when you see lots of different employers in your day-to-day life, which many of you will do, and certainly I do through the lens of my clients, what we need to have successful workplaces and better workplaces is more successful employers. It's the most successful employers that offer the best workplaces to their employees in terms of flexibility, in terms of productivity, in terms of reward. All of those things are driven by successful enterprises. Here, this Act, which calls itself the Fair Work Act, has actually become a misnomer. This is the Workers' Rights Act. It does not regulate work. It says nothing about productivity. It says nothing about flexibility. It says nothing about the efficiency of the enterprise beyond vague references in objects of the Act. The things the Commission is compelled to have regard to and not have regard to do not place emphasis on these things. And that's deeply problematic. Finally, all I'm going to do is agree with everybody else here. So we already see the increased compliance cost, which is substantial. That's going to increase further over the short to medium term. These laws will limit flexibility and productivity because they compel outcomes without having regard to those matters that are actually important. And they stop the Commission from making orders even where it thinks that it's necessary to do so. They'll fail to deliver improvements in productivity as a result, whilst driving costs, and the situation will only get worse. Judith called it an overreach. I wholeheartedly agree. I think there is the potential for this legislation to blow up in their faces, which brings me to my final point, which is the case for reform. As I've said, and for the reasons I've said, I think there will both be a moral and an economic case for reform that is in fact at its heart pro-worker. The problem is it's going to take time. If you think back to the first birth of the H.R. Nicholls Society, the gap between the debate commencing and the reform happening was 7 or 8 years. Now, that actually is remarkably quick. That is a well-executed plan. So it's going to take time. I think the major concern as a practitioner I come to with this is that as these institutional settings produce workplace results, it becomes much more difficult to dismantle them. And over that time frame, we will see the substantial time and cost of this system biting the economy. I fear that that's going to be necessary before there will be a pub test result that actually causes widespread support, political support, the pub test support for workplace change. But the debate has to start now, because it's public scrutiny of these problems that starts the process. It's the power of subtle change that can be made in the meantime that will bite. So thank you, H.R. Nicholls Society. We need multiple voices in this debate, and I'm going to leave it there.